the draft, then you call the judge who is not generating.
Yes, that
and
is
you peer review and you agree.
So there is the account, like for example, you were in Nyeri, you did a good job. You were in Malindi, you did a good job. But for the public, how are they to tell, merely because you sat in Nyeri with two other very competent judges, three competent judges, that you are the one responsible for the output? Because you are three, and we want to see that just the way we are assessed in the High Court. If I go to, like you were in Kitale, for that 1 year we can say, yes, you did a good job. So I want us to focus on the individual, because it is the individual we want to judge.
Okay.
Yes. So what is it that, how can we judge the individual judge in a multi-member court?
Thank you, my lord. I think you judge the three. The success belongs to the three. It cannot just be one judge who delivered. It is the bench. It is those who are judgments and the rulings of the bench at Nyeri that comprise the Honorable Justice Vislam, the Honorable Late Professor Ondek, and Martha Koome.
Okay. Now, you see, we are supposed to make a choice of who amongst these judges is to go to the Supreme Court. So we are agreed with you. You've done well. But you know, moving to the next court also we have to assess the intellectual heft of the candidate, isn't it? You agree with me? And it's not only for the JSC here, it is for the public, because that's what accountability is. The public must be able to see that Judge so-and-so, this is the kind of work they do. Now, when we asked you to give your sample writings, you gave 4 judgments and 1 article, the article which you have referred to, which my colleague, Commissioner Warsame, has taken you through. Those 4 judgments are judgments of the court. They are judgments of the court. And as I said, these are multi-member court. You're saying you wrote them, but you see, for the public, we have no idea. We see 3 names there. So how are we to judge you that you are the intellectual leader and therefore deserve to move forward?
I don't know whether I can say this publicly, but when it comes to giving sample writings, my conscience will not allow me to give a judgment that has been generated by somebody else. So the ones that I gave are the ones which I was tasked with the responsibility of generating. And then because the others agreed with it, there was no need for them to write separate ones.
Yeah, because you see, that is what we may perceive, but see, for the public, they don't know.
Yeah.
They're just saying that court, Court of Appeal, always delivers judgment 3 people. So for example, if the public were to ask, this is the Court of Appeal, tell us who is the intellectual giant in the Court of Appeal, what would you use as a metric for measurement? Because as a JSC, that is what we are supposed to ask ourselves. Is Judge so-and-so up to the task of being the intellectual leader? And we look at your judgment. So you say, this is my one judgment where I delivered. And the public should be able to see, this is my one judgment where I delivered.
Everybody in the Court of Appeal is an intellectual giant, but speaking for myself, I'm an intellectual giant also. Speaking for myself.
Yes, but in the Court of Appeal, you are content to be together with the others, hide with the others, so that you just do the same judgments, all of you together, isn't it?
I do not do that. When occasion demands, my Lord Judge, I write my own dissent. Yes.
So, how many dissents have you written?
I've written several. I've written a couple of them.
And those the ones you were supposed to tell us, this represent, and by the way, when you asked about dissent, you made a very good suggestion. You said it's futuristic, it is something. So don't you agree with me that in fact those are the ones who would have been happy and the public would have been happy to see?
Well, on insight, if that is what the expectation of the commission was, maybe I missed the point. But if you go to Kenya law and tap my name, and many judgments will pop up. even where I've written a dissenting opinion will pop up.
So, on that issue, don't you think it is the time multi-member benches, for purposes of accountability, to insist that judges write their individual judgments?
It's really a very good idea, Myron, for
because
every judge to write separate judgments. But look at the capacity of that court. Only 12 judges hearing appeals all over the country. Because when I say 12, you know, my Lord Justice Wasame sits in the commission.
No, I understand.
The president has administrative law.
Yes.
My Lord Justice Kadurima is at the JTI and now at East Africa. So we are left 12.
Yes.
So 12 traversing the whole of this country and each writing a judgment in a matter, you know, the ordinary matters where we have not disagreed on anything. We are in agreement. We all went to court. We conference before going to court. We went to court. We had the matter. We came back. We conference, and we are all in agreement. This appeal is for allowing.
Yes, that
now,
is why
expecting each judge to write their own draft in all those matters, I think it's a tall order, even in terms of judicial time. So when the capacity is enhanced and all the systems are working, technology is working, researchers are in place, they are there now, but they need training because they were newly recruited. When all systems are working, we can expect every judge to write their own.
Yes, and you know, I have looked at other intermediate court of appeals. For example, I was just checking in Tanzania, where actually it is one judge who writes, and then the other said, okay, we agree. So you are able to see that this judge is consistent in this way. They are not, you can be able to judge somebody by what they are able to do. So that is something I think one has to reflect on, because if you're all writing the judges together, then the issue of accountability is lacking. And for me, when you present the judgments as they are, then I have a problem. Yes. And it is something that is... so what is the responsibility of the one judge? The one judge, you are three. What is your responsibility in terms of that accountability, both to the public and yourselves?
A judgment is issued which gives reasons, justification. Because I'm part of that judgment, I read through it and I make my comments before the final draft comes out. We could be having even 3 drafts, because I'll get the draft, I'll get the file, and I'll put in my input. The other judge will do the same. They will be corrected, and sometimes we call another conference. So by the time the judgment is being issued, you all agree, this is what we wanted. It has come out. We own it. Yes.
And that would not be difficulty. For example, they said, Mother Koome JA, this is the judgment, and we all agree. Would there be any difference?
There wouldn't.
Yes.
Yes.
So that is an issue of accountability.
Yes, and because JSC is responsible for the independence of the judiciary and accountability, when we go to the conference of judges, this is something to throw on the floor for the judges to adopt.
So that brings me to the judgment of the court, because it is the judgment of the court. It's one of Communications Authority and Okea Omtata. You remember that decision?
Yes.
You delivered the judgment on 24th of April?
Yes.
Yes. You recall what happened thereafter?
Yes.
What happened?
There was a backlash.
Yes.
And this is why I brought it, because it brings out the issue of communication to the public.
Yes. So there was a backlash. In fact, they said, if I may just paraphrase, they said the court allows the government to tap phones.
Yes.
Yes. So there are 3 things I want to put to you. 3 things, and answer how you would resolve them. 1, the court was not very clear in its judgment. Maybe somebody read and they misinterpreted. So that's 1. Number 2, the court is not alive to the manner of communicating this kind of issues in this day and age. So maybe you deliver your judgment and put it in the folder, and you leave everybody to
Yes.
to say what they want to say. Number 3, maybe you did not communicate the outcome properly. So first of all, which of those 3 led to that kind of a situation?
First of all, the judgment is very clear that the judge was wrong to say that the communications authority breached the rights of Kenyans by allowing that system, DMS, which was to tap communications. That was not founded on the facts before the case.
Let me just stop you there. Fine, the judge said what he said.
Yes.
My position is, and the question I'm asking, you see, you can write all that. So the issue I'm asking, I relate to you 3 scenarios. You have said 1, that the judge has, the judgment was very clear. Maybe that's not what the public read. Maybe that's not what and we have had those situations. Even on Sunday, I believe there was a judgment of mine and they said something else. So what I want you to tell me is those 3 situations, what is your solution? What is your solution?
Very good. This is establishing a communications department within the judiciary that communicates judicial decisions to the public, because I think we have to look at the capacity of the existing department and see whether they have capacity to decipher what is the ratio, what is the determination, and what are the final orders. And only that we are so constrained in our court in terms of room and resource. Every time we have met as a college of judges of the Court of Appeal, we have said when the court is issuing a decision that has a public interest connotation in it, there must be a brief to the press, a summary of this was the case, and this was the decision of the judge, the ratio, and these were the orders.
But let me stop you there for a minute. Can it be argued, for example, that actually the burden is on the court to explain those issues very clearly so that any Kenyan doesn't need a second document to tell them what is it the court was trying to say, what is the ratio, what is the obiter. I mean, shouldn't the judgment just, if you put it out there, isn't that the obligation of a court, particularly as you go higher, your burden becomes higher, that you're speaking to the public? Isn't that something?
Yes, that is the way it's supposed to be.
Okay.
But you know, because of COVID, we are challenged completely. Right now, we are issuing our judgments online. There is even no interaction with the public. They are being issued online.
Okay.
But we are perfecting our systems. We are perfecting our procedures. We are embracing the best practices. So this is work in progress.
Okay.
And also bearing in mind the constraints in
the second issue, the social media got ahead of you. How do you deal with that?
Yes, so we also need our social media, which is activated as the Court of Appeal. I don't think we have these handles that I see being used, the Twitter handles. Those I think are for the judiciary. The Court of Appeal doesn't have. So those are things to look into so that we are also transmitting information, simultaneously with everybody else.
And that brings me to the case of Caliph Khalifa. You remember that case?
Yes.
And you know it has been the subject of a complaint.
Yes.
Before the JSC, that complaint was dismissed.
Yes.
Maybe very briefly, tell us what you understood the complainant to be complaining about, in your own words?
The complainant was complaining about a sitting of the Court of Appeal that happened the day before the repeat of the presidential election in 2017. What happened, a judgment was issued in the High Court declaring that all the returning officers and their deputies were illegally in office. An appeal was filed. My lord, the Attorney General, was the president of the court then. I was working in the bench in Mombasa, Marindi. But as you all know, the Court of Appeal is a circuit court. Even if you're in Mombasa, in fact, we used to do 3 weeks in Mombasa or 3 weeks in Nyeri and come to Nairobi 1 week because the backlog of cases was in Nairobi. So that particular week, we were all in Nairobi to do an RRI exercise. And therefore, the day before that election was a public holiday. I was called by the registrar, Mr. Selem, and I believe you have asked him questions here when you are determining the dispute, and told that the president has said, has certified a matter urgent, and has sent the bench comprising of Justice Githinji, Sishale, and Koome hears the urgent application. We should not lose sight that this was a determination of an election which is taking place the next day. Presidential election which is taking place the next day. So it was
you were called,
urgent,
you sat,
I was called, I came.
You came. Now I want to ask you, and I'm not concerned about the merits of the decision. The JSC has already dismissed the case. Complaint is this: when you sat, you had one advocate before you.
Yes.
Isn't it?
Yes.
You, as a member of that bench, did you, for example, ask, where is counsel for the other party?
We did ask, but we were told, and the council argued, the matter is very urgent. There is no time to serve because the elections are taking place the next day.
So it was about how?
So it was an ex parte application.
Okay, it was an ex parte application. Under the Court of Appeal rules, and do we have ex parte hearing of ex parte applications other than applications for urgency?
There is, when the justice of the matter requires, the overarching objective in the administration of justice, that you use your discretion to see where the justice of the matter lies, and that is the one we used.
Okay.
And to see that tomorrow is the day set by the Constitution for the election, and shouldn't they happen, there was going to be a constitutional crisis. The matter before us, what does it say? It is touching on the presidential election. We all know the presidential elections disputes are handled by the Supreme Court. And my lord, I think the Supreme Court determined that matter and said it is the one that has the ultimate jurisdiction.
Yes,
to determine.
I understand. All I'm
Yes.
concerned about
Yes.
is that it does not appear, and this is critical, because it does not appear either from your decision that you even inquired and said, because in this day and age you can pick up the phone and call. Remember, the judgment had just been delivered that day.
Yeah.
There was nothing difficult about telling the registrar, can you call Mr. So-and-so who appeared to come and deal with the matter. There is no indication on the record. There is no indication in the decision. So you can understand a litigant who is horrified and who is accusing the court of doing its own things, isn't it?
Yeah.
So what was the difficulty about just saying midnight or 1 hour, can you call Mr. So-and-so? Just the way you came here to call and come. Was there any difficulty?
You see, my lord, This was an ex parte matter. That is what we understood. The presiding judge was Justice Githinji. I believe we discussed the matter. We discussed whether parties were served, and we discussed our jurisdiction to make an interim order, and we found we could make the interim order.
So that is why I've been asking. You see, you are in a multi-member bench.
Yes.
And it is your responsibility to say, okay, we are here, 3 of us, but have we served the other party? Because that's a serious issue, and we have even dismissed magistrates for failing to do that. And you know, as the Chief Justice, the days we are going into, who authorizes the court to sit after hours in the judiciary?
Well, it is the presiding judge, the president of the court, under the Court of Appeal Administration Act. It is the president of the court who constitutes benches and who prepares the course list. So when the president of the court certified the matter and constituted the bench, said the matter be heard today because of the urgency, it is him I'm answerable to.
Don't you have an obligation, for example, to ask, has the Chief Justice authorized us to sit after hours? What is your responsibility?
As long as the president of the court had already prepared the course list, empaneled the bench, called me to sit, and I myself, using my own discretion as a judge and a senior judge, appreciating that this is a matter of national importance that requires an intervention, I knew when we are dealing with the presidential disputes, everything is urgent. You saw the Supreme sitting through midnight.
Yes.
So this was a matter extraordinary circumstances which do not occur every day.
Okay, so they don't occur every day, but first, so we don't know whether the CJ authorized. 2, we know that the other party was not called, or rather, as a judge, you did not ascertain. Now, then you make the decision. Are you aware that, in fact, this decision is not even on EKLR, the decision that you made?
I'm surprised it's not on EKL because all the decisions of the Court of Appeal are transmitted, and it's not me who transmits. We have an office of the registrar that is the one responsible for transmitting to EKL.
Yes. But you can see why somebody has a valid complaint that justice was not seen to be done. You understand why?
Incidentally, that matter is seen 2 ways.
No, I'm just saying, 1, you don't call me. 2, you make the decision. He says, look, the CJ should have authorized, he has not authorized. 3, you make a decision, which I never get to see. Is there a basis for a valid complaint for somebody to say justice was not seen to be done?
In fact, it's today I'm hearing that.
Yes, and that is why I keep raising the issue of accountability of a single judge in a multiple bench. And you cannot hide behind the president said or the presiding judge said. A judge who sits in a multiple bench is also responsible. And lastly, on that issue, you have done this as a matter of urgency. And by the way, we have said we have no problem with the decision. You had to make it. You have done this as a matter of urgency.
By the way, just to correct you, my lord, the Supreme Court cleared it completely.
Yes.
Said those returning officers were
that is fine.
Office, and that that suit was null and void from the beginning.
That is fine.
Yes.
That is fine. But you know, justice is a process, and the person who brought the case is entitled.
Yes,
is entitled to be given that opportunity.
Yes.
If it is, and no, I don't think that the Court of Appeal dealt with it ex parte anyway. At least he had the chance to be heard. So you have determined this application. In fact, was there an appeal? And you see, you have filed. You have given orders which are basically final. Did you find out to say, okay, we have certified this matter as urgent? there is an appeal pending here. Why don't we fix it for hearing as soon as possible? Because there is somebody who is concerned about this matter.
Well, thank you for that. But it is not judges who move the appeals. The parties themselves file the appeal. But I just want to refer you to the Supreme Court decision in that dispute, where that matter was actually completely dealt with, and they said there cannot even be an appeal because the court that handled the matter had no jurisdiction. So no appeal rise. Yes.
No,
the matter was finally determined by the Supreme Court.
The point I'm making is that we have a disgruntled citizen who was treated badly by the court.
Please, can we read for him the Supreme Court decision so that he can understand no appeal lies? The Supreme Court finalized the matter.
This was process, and process is important.
Yes.
This is just about process. It's not about the decision.
Yes.
And that's the point I am trying to make. It's just the process. Because if, for example, and it is going to happen, it may happen, somebody is taken to court at 5 o'clock.
Yes.
What is the magistrate? What is the message we are telling the magistrates?
No, the circumstances are completely different. You cannot look at this case, which has had such a magnitude of a causing a constitutional crisis to our whole country, to an accused person arriving to court.
Okay.
So we as judges, we look at circumstances the way they are, the way they are situational, the way they are brought.
Okay. Yeah, I will leave that issue there. Now, in the same case, you dealt with Anarita Kariminjeru.
The case of?
Yes, Anarita.
The case of?
Anarita Karimi, the famous case of Anarita. And you said that, look, this petition ought to have been dismissed and whatever, because it did not comply with the standards set in Anarita Kariminjeru. Nevertheless, we will continue to go ahead to consider. Am I right? In a similar case, that is Trusted Society of Human Rights. You recall that case where the court robustly held that Anarita was good law. You recall that case? Held that Anarita was good law, that in fact the court should not depart from it. Yes. And in fact, in that case where the High Court judges said, look, as long as you are setting out something, we are entitled to consider it. But the Court of Appeal said, no, you are bound by it. Then in this particular one, you say, oh, by the way, your pleadings really are not up to that standard, but we will consider it. What is the state of Anarita Kariminjeru in terms of our jurisprudence?
In terms of predictability of the judgment and the law and the preparation of pleadings, especially when one is seeking an interpretation of the Constitution, claiming violations of their rights, Anarita Karimi is still good law, because you have to plead with particularity what were the violations, so that you inform the other party who has violated your rights. Usually it's the Attorney General on behalf of the government, and the court is also able to interrogate, these are the particular facts. So these cases differ according to the circumstances under which they are brought. So sometimes it's very difficult for a judge to give a broad view without the actual facts before the court.
And this is why sometimes we have to be reflective. Because in the Trusted Society case, the court had dealt with a Chapter 6 issue, isn't it?
Yes.
And that is the High Court. They had said certain things, and the Court of Appeal reversed. And from the public point of view, the High Court had made a good decision, and because it led to the removal of somebody from a position. In this one, the public perceives that in fact CCK was doing the wrong thing, but the court excused non-compliance with the Anarita to give a decision which was favorable to the state. So, is that something that the court should take into account in terms of how it deals with procedural issues, so that it gives everybody a fair chance, so that if you are saying Anarita is not good law, apply it across the board, irrespective of whether it is something that favors the state or somebody, or you just say it is bad law and let us all deal with it on the same plane?
Yes.
Yes.
Thank you. Actually, I'm trying to figure out the facts in the Trusted Society case. I'm not quite getting it, but as far as the CCK case is concerned, the point of departure was, first of all, there was no evidence that the DMS was a system that was capable of eavesdropping any communication. Number two, the process of consultation, public participation, had not been completed. It was in the midst of it that Omtata went to court and nipped the whole process in the bud. So the process of public participation had not been completed, and therefore the problem that was there with the CCK of having to deal with the purveyor who had invaded the mobile telecommunication was still a problem there, recognized not only in Kenya, but regionally and internationally. And it's a problem that needed to be dealt with, but properly, with proper consultation to the public, proper agreement on how the system was going to work. So we did not say go install the system. We said go back, consult the public, finish the consultation, then agree with the public how to install it. But now if that judgment was to stay, the problem would have stayed in the market, affecting a cross-section.
So at the end of the day,
economy.
we agree that Anarita should be applied in the circumstances of each case.
Yes.
Thank you. Just two more questions, or probably one. In the case of, you remember the case of, this is a very straightforward question. In application of international law in Kenya, you are a trailblazer in that area. Article 2.5 and 2.6. I just want you to tell me, or to tell us, the application of international law vis-a-vis the hierarchy of laws under the Judicature Act. You know, the Judicature Act talks about the Constitution, statutes, those statutes that have been incorporated, common law, and Africa customary law. So you have a statute that has been incorporated, so it's legislation. In that hierarchy, where does the general principles of international law fall?
Thank you very much for that question. I believe the principles of international law will come after we have exhausted our constitution, which is very progressive, very encompassing. Sometimes it has even gone ahead of those international provisions, and it is very rare that we have exhausted the theory is the principles that are provided in this constitution.